I speak to law students from the best law schools, people presumably especially interested in the law, and I ask them, how many of you have read the Federalist Papers? And, well, a lot of hands will go out. No, not just number 48 and the big ones. How many of you have read the Federalist Papers, cover to cover? Never more than about 5%. And that is very sad. I mean, especially if you're interested in the Constitution. Here's a document that says what the framers of it thought they were doing. It's such a profound exposition of political science that it is studied in political science courses in Europe.
A Synopsis of Constitutional Law by Redlich, 2002, Chapter 1, The Judiciary. Looking at the origin of the judiciary in the United States, the conflict between the other branches of government, and how that conflict has existed in the judiciary's growth in power and stature. The first topic in Chapter 1 involves Marbury versus Madison, the 1803 case, going over the history and purpose. The first two questions start on page 1. And the first question, and I quote, "Do the laws of his country afford him a remedy?" Also known as adjudication. The second question, and I quote, "Is it a mandamus?" Which means we, the court, command. End quote. These two questions pertaining to Marbury versus Madison and the foundations of the courts basically ask, is there an injury to remedy? And if there is, do we have the jurisdiction, the appellate, or original jurisdiction to command such a remedy? And that comes into play with judicial review and the court's ability to declare an act unconstitutional because, as we are going to explain on page 6 very soon next, is if Congress, if the legislative power passes a law that is unconstitutional, that is well beyond their powers set out in the Constitution, which branch, which body has the obligation, has the ability to declare that to be the case, to declare that law unconstitutional. And here on page 6, I quote, "The powers of the legislature are defined and limited." End quote. Courts can act to void unconstitutional acts that go beyond Congress's powers, also known as judicial review. Marbury, the 1803 case, held that the court lacked jurisdiction because the Judiciary Act of 1789, Section 13 of said act, which gave jurisdiction to that court, was unconstitutional in itself. And this idea of judicial review, of the formation of the court's power, has its origins, of course, later in history. The founders got their ideas from in the classics. But in this cause, the idea of judicial review also has its origins from Federalist 78 by Alexander Hamilton. And I quote, "A constitution is in fact and must be regarded by the judges as a fundamental law." End quote. Hamilton argued that the judiciary should have some power of judicial review. The next topic is departmentalism. The definition and argument. The departmentalism means that each branch of government has a duty to interpret the Constitution and uphold it. This idea of the cooperative aspect of government in the national government of the sharing of powers and the separation of that power, which we will go over later in this synopsis, has its founding in the founding period of our nation, but also has its relevance in one of the most important constitutional questions this nation has endured, which was a civil war. And during that time, Lincoln argued that all branches of government have interpretive powers. In doing so, he pushed back against court orders which tried to limit his war powers and his ability to suspend habeas corpus. He used his constitutional powers as president to check the court that he deemed was too radical, that was abusing its power. And in that defense of his actions, Lincoln argued, and I quote, "The candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the instant they are made in ordinary litigation between parties in personal actions, the people will have ceased to be their own rulers, resigned their government into the hands of that eminent tribunal," end quote. The next topic covered in Chapter 1 was jurisdiction, previously touched on. On this section, a topic, it goes over the definition and the powers. Jurisdiction is, I quote, "power to declare the law and when it ceases to exist, announcing the fact and dismissing the cause," from page 28, end quote. This is also found, the question of jurisdiction, laid out in the Constitution, but also backed by an important case. In the Palmer versus United States 1973 case, I quote, "Congress had jurisdiction regarding the creation and jurisdiction of lower courts. Congress had the discretion over that jurisdiction of the lower courts." So this just went over the definition of jurisdiction, what jurisdiction is, and and an example of a constitutional, of a court case, which backed up and defined that jurisdiction, that discretion that Congress was given by the Constitution to establish lower courts and to give them their due jurisdiction. And that was found on page 31. The next topic is the separation of powers, as previously touched on. It's designed for the judiciary. I quote from page 34, separate the legislative from the judicial power. One branch should not have the power to make the law and then the power to judge the law. One branch should not have the power to write the law and consequently also have the power to interpret the law. This is a hallmark of American democracy, separating those powers from each other. The next topic is the doctrine of standing, its definition, an example, and its purpose. Starting on page 47, I quote, "Serving to identify those disputes which are appropriately resolved through the judicial process is the doctrine of standing." End quote. Only plaintiff, only the person bringing the case with a concrete personal stake, a demonstrated injury, can start a lawsuit, can initiate a lawsuit, can bring a lawsuit against another party. Courts should not enforce the law progressively, but only decide cases based on facts, based on standing. And an example of this, and I quote, in United States versus Hayes, 1995, the court dismissed a claim that a congressional district was the product of a racial gerrymander because the plaintiffs in that case resided in and adjoining in a separate district rather than in the district concerned. Page 59, end quote. You have to show direct injury to have standing. And when there is no standing, there is muteness, a moot case. I quote, mootness, like ripeness, involves a timing question, end quote, from page 61. Is the injury currently ongoing? I quote, the court has recognized that an issue should not be decided if it is not ripe for judicial review, end quote, page 65. Courts, on this point, on the point of standing and of mootness, the courts should defer political battles to the political branches. An example of this. Surrounding the war powers, the Constitution splits the war powers between Article 1, the Congress, and Article 2, the President. Congress shall have the power to declare war, and the President is endowed with the title of Commander-in-Chief of the Armed Forces. Congress also has the power to establish the military budget. So when there is a dispute surrounding the war powers, for example, the War Powers Act, the courts usually and have defer that question to the political branches to work out, to use their powers prescribed by the Constitution to check each other. But at a point, when that becomes too much, if impasse exists, then the court may assist. They have standing. They have an actual injury that cannot be resolved on its own, that requires a third party from the third branch of government.